I think there's a couple of things that I had mentioned earlier on as far as considerations that we did as far as the rule is before I actually read it out. Number one, as I had mentioned before, because there was pending litigation around the issue, the Attorney General's office was consulted on this issue prior to the rule language considered. This does not mean that they agree or don't agree with it, but they have seen the rule, they understand it, they've seen it, and they've been able to weigh in and make suggestions as they are also represent us as a board when there are other issues that are out there. Additionally, speaking from that standpoint, I had mentioned earlier on, but not all of you may have been here, but there is language that came specifically from the Supreme Court that I think it's important for all our licensees to know, but more importantly for the public to know. And again, specifically, and I'll read out the language from the Supreme Court language itself. It says, a woman who meets the medical necessity exception need not seek a court order to obtain an abortion. Under the law, it is a doctor who must decide that a woman is suffering from a life-threatening condition during a pregnancy. Raising the necessity for an abortion to save her life or to prevent impairment of a major bodily function, the law leaves to physicians, not judges, both the discretion and the responsibility to exercise their reasonable medical judgment given the unique facts and circumstances of each patient. I would remind everyone that this is directly language from the Supreme Court ruling itself. So as we talk about the language of the rule, I just want to make sure that those 2 points are clear and that they're out there. And as I said earlier, the medical board will issue a press release that goes into a little bit more detail on our consideration and the process itself. So with that, typically we don't necessarily read proposed rules in detail line by line, but in this case I will, and then I will move it to deliberations between the board members after that. So this is Chapter 165, Medical Records, Subchapter B, Exceptions to Abortion Ban. 165.7, Definitions. The following words and terms, when used in this subchapter, shall have the following meanings. Abortion means the act of using or prescribing an instrument, a drug, a medicine, or any other substance, device, or means with the intent to cause the death of an unborn child of a woman known to be pregnant. The term does not include birth control devices or oral contraceptives. An act is not an abortion if the act is done with the intent to A, save the life or preserve the health of an unborn child, B, remove a dead unborn child whose death was caused by spontaneous abortion, or C, remove an ectopic pregnancy. The definition is found at Chapter 25, Section 245.0021 of the Texas Health and Safety Code. Ectopic pregnancy means the implantation of a fertilized egg or embryo outside the uterus. And removing an ectopic pregnancy is not an abortion. This definition is found at Chapter 245, Section 245.002 4A of the Texas Health and Safety Code. 3. Reasonable medical judgment means medical judgment made by a reasonably prudent physician knowledgeable about a case and the treatment possibilities for the medical conditions involved. This definition is found at Chapter 170A, Section 170A.0014 of the Health and Safety Code. Medical emergency, number 4, means a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as certified by a physician, places the woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. This definition is found at Chapter 171, Section 171.002, 3 of the Texas Health and Safety Code. Number 5. Major bodily function includes, but is not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. This definition is found at Chapter 21, Section 21.002, 11A of the Texas Labor Code. 165.8, abortion ban exception performances and documentation. And I believe this is the second part of the rule. A, an abortion shall not be performed in this state unless it is performed in compliance with all provisions of Texas Health and Safety Code Chapters 170, 170A, and 171, in addition to any other applicable federal and state statutes, rules, and court opinions. B, in addition to the requirements above, the physician must specifically document in the patient's medical record, 1, that the abortion is performed in response to a medical emergency. A, underneath 1, that places the woman in danger of death unless the abortion is performed or induced, or B, to prevent a serious risk of substantial impairment of a major bodily function of the patient unless the abortion is performed or induced. Number 2, the major bodily function or functions at serious risk of substantial impairment. 3, what placed the woman in danger of death or what was the serious risk of substantial impairment. 4, how the danger of death or serious risk was determined. 5, how the decision was made to proceed with an abortion based on reasonable medical judgment, including A, what diagnostic imaging, test results, medical literature, second opinions, and or medical ethics committees that were used or consulted, and B, what alternative treatments were attempted and failed or were ruled out. Number 6, how determination was made that performing a procedure in such a way as to give the child the best opportunity to survive would create a greater risk to the woman. And 7, whether there was adequate time to transfer the patient by any means available to a facility or physician with a higher level of care or expertise to avoid performing an abortion. The third section, 165.9, complaints regarding abortions performed. A, the Texas Medical Board will review complaints and perform investigations regarding abortions using the board's standard complaint process. B, if a complaint is determined to be jurisdictional to the board will use independent expert physicians as provided in Texas Occupations Code, section 154.0561, to review the available information, including the patient's medical record. C, any decision by the board to either dismiss the complaint or discipline the physician who is the subject of a complaint is separate and independent of any other possible criminal or civil action under the law. If the board is aware the licensee is subject to a pending criminal or civil action, then the board may defer or delay action. Depending on the outcome of criminal or civil action, Texas Medical Board retains the authority to investigate and potentially take disciplinary action. That is the text of the rule. I'm now going to open it up to the board members to ask questions and to deliberate between us as board members.